Good afternoon, everyone, and thank you for coming to our webinar on privacy and data protection. I'm just going to wait a few more minutes while people join to the session. So thank you for your patience. We'll get started in a few minutes. Okay, I think we're ready to go. Danielle, are you there?
Yep, I'm here.
Okay, perfect. So we'll get started. Good afternoon, everyone, and welcome to this webinar on privacy and data protection in the US. This is the fourth in the series of data protection webinars that Danielle has presented. So I just want to say upfront, thank you, Danielle, for all your hard work on this very important and interesting topic. Before we get started, I'll just ask you to feel free to put in your questions in the QA box at the bottom of your screen, and we will get to them as they come in, and we'll also have a small or short question period at the end. So right now I'll introduce your speaker. Today we have once again Danielle Olofsson to guide us through this data privacy topic. She's based in Montreal and is responsible for BCF's compliance with existing data protection and privacy legislation. She also advises clients from a variety of industries such as pharmaceutical, medtech, financial services, and communications on a range of matters linked to privacy, data protection, and cloud computing. She assists with compliance, breach identification, and notification, cross-border information transfers, and privacy program management. She is particularly versed in the privacy and data protection issues relating to new technologies such as artificial intelligence and blockchain. Danielle is an International Association of Privacy Professionals certified expert in Canadian and European data protection, as well as in privacy program management. Danielle, the floor is yours.
Thank you, Lucy. Can everybody hear me? Lucy, can you hear me? Lucy?
Yes, I can hear you. Participants, if you want to just type in yes in the chat so we know that you.
Perfect. All right, I put a headset on today because yesterday,
Okay, so that's great. People seem to be hearing you. Yeah.
Okay, perfect. I don't know, can anybody see me? That's the next thing. Can you see me?
No, I don't see. I see your screen.
That's so strange. No. I'm going to try and, because I didn't activate the camera. There we go. All right, I'm at home because yesterday there was a tremendous amount of feedback at the office, unfortunately, and I'm sorry about that. So I've put on a headset. If there is feedback or if there are any problems, please, please, please let me know. Again, please ask me questions throughout, and I'll try and answer them. Lucy, do we have two? We already have two questions.
It's just the people confirming for the audio.
Perfect. Okay, thank you. All right. Today we are addressing the last of the topics that we started with this privacy series. And what we're going to talk about is American, and especially the federal privacy regime in the United States. This is a regime that I've come to later in life after having confronted a whole lot of prejudices, thinking that the Americans were cowboys, they didn't know anything about data protection, and we knew everything better than they did. And I was certified an expert 3 weeks ago in this field, and it was a really difficult exam, and I realized how utterly wrong I was. It's just a very, very different approach to data protection than we're used to in Europe and in Canada. It isn't a comprehensive approach. It's a very sectoral approach. And it's just a different way of dealing with these topics. And we all know that America is not great on trying to restrict rights or tell people what to do. And this is reflected in their data protection legislation, and that there's a maximum amount of freedom given to an individual to act as stupidly or as foolishly as they want with their information, but there's still some recognition that there are certain places where people need to be protected despite themselves. So what's really interesting about this legislation is that it's very case-based and it's very problem-based. So if there's a problem in a certain sector, there's a piece of legislation that appears to address this problem, but there is no sort of overarching comprehensive body of law based on the same set of principles that protect people regardless and irrespective of the area in which they're dealing. So with that said as an introduction, let's try to go to the next slide. What I want to do is just provide an overview, and the overview is probably one of the more interesting parts because it helps to understand how the United States deals with data protection. And then I thought I would go through the various sectoral federal laws. It looks a little dry. I'll try and keep it interesting. I wanted to finish also on the California Consumer Privacy Act, which is an act that's causing a lot of stir right now. I think they've just finalized their regulations. So it was supposed to come into effect in January of this year, but we were waiting for regulations for further details. It's an extremely interesting piece of legislation, very similar to the GDPR, ironically enough. And then I wanted to mention a few other states that have begun to pass their own data protection legislation. So, as you know, the United States is a federal structure, which means that the federal government has jurisdiction over certain things and the state governments have jurisdiction over certain things. And this is one of the reasons that it has been difficult to pass an overarching federal law, is because the states are so powerful. So when people say, oh, well, the Americans don't have federal data protection legislation, okay, fine, that's a fair statement, but a lot of what our legislation does can be found in the state laws. Makes it complicated because you have to go through each of the states to figure out what they're doing, but a lot of it's very similar. For instance, the states are the ones that administer breach protection. So every American state, including Puerto Rico, I think, and the Virgin Islands, all have data breach requirements. So if your company suffers a data breach, you have to notify people. You have to notify the, I think it's the Attorney General, and you also have to notify the individuals who are involved. You may even have to notify the media if they're more than, it's usually 500 people involved in the same state. So they're extremely strict breach laws that are applicable, but they're applicable at the state level. Also, the time frame in which you have to notify can be very limited in certain instances. So it's very important to keep that in mind. The next big characteristic of the American data protection regime is the sectoral approach. I keep saying this. What this means, or what I mean by this, is that certain sectors are deemed to be more vulnerable and therefore warrant greater data protection than other sectors of the economy. So healthcare, for instance, is deemed to be a very important sector that requires robust data protection legislation. Obviously, financial services is another one. Online children, the use of online children, the use of the internet by children. There's a tremendous amount of regulation around that. what are some of the other ones I've dealt with? Communications, telecommunications is another area. I'm touching briefly upon employment, but there isn't a lot in the federal sort of purview that touches on employment, but it's important to know because employment is one of the areas in which privacy breaches happen more frequently. And then the third characteristic of American data protection legislation is that it's enforced, the main body responsible for its enforcement at the federal level is the Federal Trade Commission, which is kind of an interesting way of approaching it because essentially companies that don't fall in the various sectors that are sort of labeled and regulated have to come up with their own privacy policies and put in place their own privacy policies. And these privacy policies or privacy practices are going to be regulated by the Federal Trade Commission. So if you believe that somebody's practice or policy has harmed you, you bring a complaint before the FTC. What that means then is that a privacy breach is viewed as an unfair trade practice. And the article of the Federal Trade Commission Act that's the most important is Article 5 that gives the Federal Trade Commission the right to sanction or to punish unfair or deceptive trade practices and unfair trade practices. And where this has become very interesting is that basically items that fall into sort of poor notice provisions or dishonest notice provisions are very tightly regulated by the Federal Trade Commission. And so for instance, first of all, a deceptive trade practice is a material statement or omission that is likely to mislead a consumer. So for instance, Snapchat got penalized recently because Snapchat was making claims that as soon as your information transited through Snapchat, it was immediately forgotten, which wasn't true. Snapchat was actually keeping that information. And so they were deemed to have been engaged in deceptive trade practices. An unfair trade practice is something that is not necessarily deliberate. So I haven't deliberately misled you or I haven't deliberately not told you something, but I've behaved in such a way that's caused you damage that you can't have known about, you can't have acted in any way so as to protect yourself. And an example of that is a company that was called LifeLock, which advertised, what was it? It was protection against identity theft. Problem was, it only protected against some identity theft and not all of it. So people who suffered from other kinds of identity theft were not covered by this policy and by their practices. And the FTC, the Federal Trade Commission, said, that's an unfair trade practice, and they punished LifeLock. Just also failure to protect your data properly. If it's found that, you know what, you didn't put the proper mechanisms in place to protect your data, that can come under Section 5 with the Federal Trade Commission. So while it's very general and very large in scope, the Federal Trade Commission does exercise tremendous power and tremendous oversight in the United States. Where it falls short, however, is anything in the transportation and banking don't necessarily come under the Federal Trade Commission. They have their own supervisory bodies. So again, it's not necessarily a one-stop shop in the U.S. You have to know where to go, but it is a very effective system. Are there questions just on the general? No? Okay. So I wanted to start with healthcare. The other thing I wanted to say about the American approach is because it's a sectoral approach, the different sectors that do have federal legislation don't necessarily define personal information in the same way. We've seen in Europe, we've seen in Canada, that personal information is in the individual relating to an identified or identifiable individual. It's not the case in the United States. It's similar, so it's usually a person's name, a social security number, or driver's license number, and then it can be a combination of any other factors. For instance, if you're talking about education, obviously student identification number. It comes into the definition of personal information, as does the student's family address. What are some of the other ones? Some of the state laws include biometric information. One state even includes your mother's name as personal identity, specifically. So there's a wide variety of how personal information is defined. So before you go and see what your obligations are, you have to figure out how it's defined, how information is defined in order to be sure that you're properly protecting it.
Danielle, sorry to interrupt. We do have one question here. So several years ago, the USA stated social security numbers would not be used as an ID. I have noticed that the 4 digits at the end are being used more frequently in bank medical ID, especially by phone. Has this law been changed back?
I don't know about the original law. What I do know is that California didn't want organizations, companies using their social insurance numbers on things like, postal things that they mail, regular mail. What happened was in the banking sector, and I'm just trying to remember the name. I'll get to it in a second. I think it's the Fair and Accurate Credit Transaction Act, said that you had to truncate identification numbers, so that, you would only provide the last 4 digits you could only disclose the last 4 digits. And it's an interesting question because this comes up in a variety of sectors. In tax, also anything other than the last 4 digits can be considered personal information. So some of the laws have come in to clarify this, but again, it depends on the sector in which you're in. Banking, it's very clear that if you're going to use somebody's credit card number or social ID number, they have to truncate it. Same with bank card numbers. They have to truncate it. I don't know if that answered the question. If it doesn't, come back to me and I'll see if I can answer the question better. The other thing, sorry, about the various sectors' approach is that they don't all favor the same privacy principles. We've seen through Europe and through Canada that you have 8 or 10, depending, privacy principles, and they've got to appear every single time. This is not the case in the United States. Some sectors favor notice provisions and consent. Others favor opt-out and disclosure. It's very, very different. So to start with healthcare, healthcare is one of the sectors that does emphasize consent and the individual's ability and the need to have individual consent when you're dealing with healthcare information. It's also an area that favors notice provisions, transparency, telling people what's going to happen with their information, and security. Security is extremely important in the healthcare sector. So I've listed 5 laws here. The one we hear about the most is the Health Insurance Portability and Accountability Act. Now what that is, or HIPAA for short, you see HIPAA bandied about all the time, the acronym. What that is, interestingly enough, it was a law that was passed to actually facilitate electronic communication of health information. So it's not necessarily a protection of health information per se. It was more a protection of how this information was to be communicated. And it applies to every every organization, every health institution that receives federal funding. So if the organization doesn't receive federal funding, HIPAA doesn't apply. So you have to just be careful about that. So what it does is it defines personal health information, and it defines it as any information, regardless of whether it's being transmitted by paper or digitally, that is stored or received by one of the covered entities. So a covered entity is a medical clinic, a hospital, a doctor's office, even a doctor, a detox center, any of these things. And sorry, I'm reading notes here. And this information then has to be protected. And what the Health Insurance Portability and Accountability Act says is that, okay, if you're going to collect this information, then you must put in place a privacy notice or a privacy rule. But they also have a security rule. So there are two rules that are linked to this particular Health Insurance Portability and Accountability Act. So one is you must put in place some form of privacy notice, which contains all of the elements that we've seen before. And then this law also says, well, okay, if you are processing health information, what you need to do is you also have to put in place proper security mechanisms so that the confidentiality, the integrity, and the security of this information is protected. Sorry, I cut myself off when I was talking about health insurance or health information. Health information then is any information that is sent or stored on digital or paper format and that deals with an individual's present, future, or past physical or mental health. So it's very large. And also the individual's payment for this information. So if any information regarding to how my information is paid for, that is my insurance company. For instance, my insurance company's name is going to be considered personal health information. Now, this act was amended by the Health Information Technology for Economic and Clinical Health Act. You'll notice that they have extremely long titles. This one is really interesting because what it did was it imposed breach notification in the Federal Health Insurance Portability and Accountability Act. So it said, okay, you know what? If there's a breach, the covered entity has to report it and has to report it quickly to the individuals and to the Attorney General. So they have 60 days in order to report a breach. So those are the two very sort of, I wouldn't say popular, but the ones that we hear about the most, the two laws that we hear about the most. There is another one, or there are a few others that I think are worth pointing out. The Confidentiality of Substance Use Disorder Patient Record Rule, which was, I think, passed in 2017. It was recent. That one basically extends the Health Insurance Portability and Accountability Act to files concerning people who have been diagnosed or are following treatment for a substance use disorder. And again, this law is very adamant that an individual's consent be obtained for the use of this information if this information is going to be reused for a different purpose. The issue in, I guess, all of these sectors is not necessarily how the initial information is used, but how it's going to be used by data processors who are coming in behind the Googles, the Amazons of this world, who want to know all there is to know about you so that they can sell you stuff. So a lot of these laws are really addressing that. We also have the 21st Century Cures Act. That was a really recent one, and what that was to do is to try and expedite research and development of medical devices. So it claws back some of the restrictions so that information can be shared more freely. What was I going to say about that one? That's basically, it's basically a law that enables, that's right, that enables, for instance, researchers to stock and to share information virtually, which they need right now. So they would be able to remove it from wherever it's being stored, their mainframe, provided that they can prove that the system that they're using is secure. So it was just a law to stop the obstacles in the way of people sharing medical information. And the final one, which I really like and I think is a fantastic piece of legislation, which we tried to emulate in Canada but failed because we went about it the wrong way, is the Genetic Information Non-Discrimination Act. And this prevents insurance companies from requiring that individuals take genetic testing as a precondition to coverage. So an insurance company cannot say, I want you to have this genetic testing done so that I can gauge what my risk is. That's not possible. And it's even extended, quite interestingly, to pension funds. Pension funds cannot do that. I mean, unless somebody has a visual, like a risk that you can see, a risk, is suffering from a condition that you can see up front, then the pension fund or the insurance company cannot ask you to have these tests taken. So this is pretty much what the healthcare sector deals with. And as I said again, with the exception of the Genetic Information Non-Discrimination Act, where it's really clamping down on a specific kind of behavior by insurance companies, the rest of the laws are really dealing with how we communicate, how we transmit information. Are there questions about the healthcare sector? No, okay. So now we get into the big one, which I think probably everybody's aware of, and that's the financial services sector. Huge. And this is one of the areas. Oops, sorry. Lucy?
Yes.
Did you have something to say?
No, it's fine. I responded.
Okay, fine. This is one of the first areas where we see legislation appearing. So in 1970, we have the Fair Credit Reporting Act. And what the Fair Credit Reporting Act, this is a good illustration of what I was talking about earlier when I was saying the American legislation is really, it really sort of targets problems that appear and okay, the legislature goes in and fixes them. But what the Fair Credit Reporting Act does is it basically, it regulates how consumer reports are, financial consumer reports are going to be handled. So what a consumer report, a financial consumer report is it's a report that's drawn up about an individual, talking about their creditworthiness, their credit capacity, their credit standing, but also their reputation, their character, any personal characteristics about them. And these kind of reports are used by employers when they want to employ someone or when they want to promote someone, or even if they want to dismiss someone, they frequently ask for one of these reports. They can be run also by insurance companies to determine whether insurance should be granted, and they're run obviously by credit bureaus to see, or by banks to see if somebody should be given credit. So what this law comes and does is it basically places some restrictions over what can be done. So the first thing it does is it makes sure that credit bureaus are properly accredited. They have to be certified. And if I'm an employer or whoever I am, if I'm going to run a credit check on somebody, I have to, first of all, tell that person, before I run the credit check, I have to tell the person why I'm running the check. I have to tell them what body, so what credit reporting bureau is going to be running the check. I have to give them the name, the address, a telephone number. I also have to say that the credit bureau, in issuing this, does not know or is not doing this so that I can take a negative action against someone. And then if something unpleasant or negative action is taken against an individual based on the credit report, I have to give that person the right to access the information, to access the report, and to make any amendments. So it's an interesting way. It's a great way of being open about what is actually going on and how people are checking your references. Now, this doesn't mean that as an employer you can't run an employee check. I mean, the employee may be behaving in a way that that is reprehensible or not in the company's interest, and you absolutely do have the right to do it. The only thing is if you're just examining company or employee behavior, you can't look at their credit information. If you're going to look at credit information, the Fair Credit Reporting Act is going to apply. California, very interestingly, has taken this act and in California has made it even more severe, so that you have to have the employee's consent in order to run these kinds of surveys or this kind of research on an employee. Whereas the federal law says, okay, if I have an employee, that employee can consent once, and I will be able, throughout the course of their employment, to run these these checks on the person because maybe I want to promote them, maybe I want to know about their character, whatever. So I may need to do it more than once in their employment career. California says no, every time you run one of these, you have to inform the individual. And not only that, if adverse action is taken, you have to give the individual the right to receive the report. And even if the individual checks a box saying they don't want to receive the negative report, you still have to provide a summary, you have to provide it to them. So these are actually, this is a practice that's taken extremely seriously in the United States. Now, what happened with this is the Fair and Accurate Credit Transaction Act came and amended this law a little bit. And what it did was it implied, it imposed what we call a disposal rule and a red flag rule on people who use credit reporting. So what that means is that if I'm running a credit agency and I'm checking, or if I'm using information that has been provided by a consumer report agency, I have to put in place disposal mechanisms. So I have to destroy the information after a certain amount of time. And that's really important so that people don't keep information too long and get confused or whatever, or base decisions on outdated information. It also insisted, the Fair and Accurate Credit Transaction Act, that we put in place red flag rules. And what red flag rules are is that we wanted to put in place rules that would show or not show, but would raise, I guess, raise a red flag if it was felt that information had been tampered with or was inaccurate. So what we see in the financial services industry is really a focus on, we see a focus on notice, we see a focus on the principle of disposal, and we see a focus on security. With respect to disposal, disposal actually, interestingly enough, is another one of these areas that the states have legislated quite heavily. And so in the same way that there's breach notification that's required, most states also have disposal rules where companies are required to dispose of information in a certain way within a certain amount of time to notify the people who are concerned. So that's what happens with the Fair Credit Reporting Act and the Fair and Accurate Credit Reporting Act. Then we have the Gramm-Leach-Bliley Act. This is an act that there's a lot of, this is one of the first ones I remember, a lot of talk about it. Again, what this act does is it says, okay, financial institutions, any financial institution has to put in place what they call the privacy rule. So you have to provide a proper privacy notice and safeguard rule. You've got to put in place proper, security mechanisms to protect this information. It also provided for, because what it dealt with was it dealt with how information was stored and how information was used. And this is interesting because at this point, what this Gramm-Leach-Bliley Act says is, okay, financial institutions, you can transfer information to third-party service providers, or you can transfer information to marketing servers, but you have to give the individual the right to opt out. And what that means is I have to be given the right to say, no, I don't want my information to be transferred to these third parties. That is in sharp contrast to Canada, well, Canada, certainly to the European Union, where individuals have the right to opt in. So if I want my information transferred, I opt in. America's, it's the opposite. I will transfer your information unless you tell me specifically not to. And this causes problems, obviously, because people don't read notices. They don't care. They don't read their notices. And so their information is transferred willy-nilly everywhere. And so this is problematic. California, again, has stepped up and has tried to control this and said, okay, well, they limit the institutions that you can share your information with. And then finally, I won't spend much time on this, the Frank Dodd-Wall Street Reform and Consumer Protection Act was just basically an act that describes who has which level has authority over what kind of activities. So banking institutions that have more than $10 billion are regulated by such an organization, and if they have less, they're regulated by another. That's what that law does. Let's get, sorry, I realize that I'm yapping and the time is fleeing. So let's get to education. Education is an area, and again, very much like healthcare, these laws only apply to educational institutions that receive federal funding. So all public schools, most private schools, and most universities. This law will apply to. If an institution does not receive any public funding or any federal government, any federal government funding, these laws won't apply. Here, the principles that we see put forward are consent, access, the right to make a complaint, and the right to receive an annual report. The main piece of legislation here, and it's enforced by the Department of Education, is the Family Education and Privacy Act. And basically what this is saying is that students have the right to control their educational records. So an educational record is anything containing any document, paper, or digital containing information concerning a student, be it their performance, but also health records. If a student has been treated on university or on school grounds, their health records may also be considered an educational record and fall under this and not under HIPAA. It depends. So what this law says is, look, the student must consent, or their parents, if the student is not 18, must consent to having the information transferred. However, it doesn't apply to anonymized information. It also doesn't apply to information that's contained in what they call I'd love to say yearbook, it's not yearbook, information that's contained in where is this? A directory, excuse me, information contained in a directory. Information contained in a directory, if the student has been given the right to opt out and has not done that, that information can be forwarded. Now, what I mean by directory is it depends on the institution, but it can be anything dealing with the student's name, their address, their email address, their honor, like their course of study. Typically their grades and their student identification are exempted from that. Now, a student has the right to have access to their record, and this law is very strict on the fact that an institution that has an educational record must give the student access to the record. If they don't do it in a timely fashion, the student has the right to contest and to be heard by an independent body. And that's extremely important, because again, we see that this is a law that's trying to provide some control for students. Certain information is not considered to be covered by this act, and it can be freely transferred. Things like information concerning a accreditation program. If an institution decides it wants to transfer information because of an accreditation program that it belongs to, it can do that freely. Certain other things, if there's an incident, a sexual assault incident, that information, healthcare reasons, like an emergency situation, that kind of information. So there are exceptions here where the student doesn't have to provide consent.
Danielle, sorry to interrupt. We have a question. We have a question here. What if a student was treated medically or in mental health department at a university? Is that protected by the act? Does the university have an act?
That is, if the university receives public funding, yes, that information is protected as part of their record, and it may also be protected under the Personal Health Information Accountability Act, Portability Accountability Act. There may be several levels of protection, but it definitely is protected in that instance, yes. And then just quickly, Now, the protection of pupils' rights, what that has to do with is it was basically trying to regulate the kind of information that pupils had to provide on questionnaires. So information regarding religious affiliations, political beliefs, sexual behavior, any form of abnormality, whatever that means these days. This kind of information, it was judged that that was too much, and they didn't have to provide that. No Child Left Behind, again, No Child Left Behind is a piece of legislation that covered what more standardized testing, what third-party providers could collect on students, and gave parents some rights with respect to saying, well, wait a second, I don't want this information about me transferred to the school or transferred to this third-party provider. So that's basically where the education, where the lay of the land is with respect to educational information. I have a question. The question is this federal public funding only? Yes, because in order to pass legislation in this area, the federal government has to have some jurisdiction, and it only has jurisdiction if it funds it. So it's pretty cynical, but that's the way it is. It can't control, because education is state. It can't start fiddling in schools where it hasn't provided the funding. So a lot of this legislation is linked to funding. Any other questions? Okay, I'll just go to the next one quickly. Telecommunications and marketing. I think the most important are the four first points. The three last ones: the Telecommunications Act, the Cable Communications Policy Act, and the Video Privacy Protection Act, are basically regulating how these service providers can use information that they receive on clients. So to what extent can they share client information? So can they share, and client information in this case is information linked to their billing, so what they're buying, what their preferences are. And this is restricted. You can't share information other than a person's, I think it's name, and name and maybe name and telephone number. Some are name and address, and a lot of some of these laws are less relevant now because the technology has changed. But what is very relevant for us are the telemarketing sales rule and the Controlling Assault on Non-Solicited Pornography and Marketing Act. So the telemarketing sales rule deals with telemarketers, but again, it defines, telemarketers to include programs that are that only work across state lines. So if you're conducting your telemarketing in just simply one state, this law won't apply. However, there are state rules dealing with telemarketing. What this rule says is you've got to put in place, if you're telemarketing, there's a do not call registry. So individuals who don't want to be contacted by telemarketers register with this, and anybody conducting telemarketing must check this registry every month before they launch a call, before they begin a campaign. If they don't do that, even if the person's name is not on the do not call list, they can still be held accountable and responsible for penalties. So a very strict rule here regulating telemarketing. It also regulates when telemarketing can take place, so between 8 in the morning and 9 at night. It regulates what you have to say when you contact somebody to sell things over the phone. It also, what else does it do? It tells you what you have to tell them if you're selling prizes. It doesn't like dead time, and so what that means is that a certain percentage of a telemarketer or the phone call cannot be silent. So this business about waiting for X number of seconds before the person picks up, that doesn't work. It doesn't like sort of rings and hang up. You have to show that you've at least let the phone ring 4 times or for 15 seconds. So there are all these rules surrounding how telemarketing is to be conducted. Robocalls and auto dialers, also very, very regulated. You can't just install robocalling. If you do, you have to adhere to the rules that are put in place for telemarketing. And additionally, you can't presume that you have received consent in order to make robocalls. When you make a telemarketing call, I should have said this, and also robocalls, you need to have consent of the person to keep going, and this consent has to be written and it has to be explicit. So this is an area where they try and privilege consent, much like Europe does, much like Canada does. When you're dealing with marketing, you really have to have the person's consent in order to market to them. Quickly, the Controlling Assault on Non-Solicited Pornography and Marketing Act is, the acronym is CAN-SPAM. It's the equivalent to our CASL, or our Canadian anti-spam law. It is not as demanding, but many of the things that the Canadian legislation have can be found in the CAN-SPAM. So for instance, you can't have misleading subject headers, you can't have misleading subjects or headers, you can't, you have to honor an individual's request to no longer send information. If you haven't done that within 10 days, there's serious reprisals. You can't just do address harvesting. You have to provide the individual with a link in order to revoke their consent. So very similar, in fact, to what happens in Canada, only it's not as severe, but it is an extremely severe law nonetheless. If even your product were to contain a naked person on it, it may be art, it may not be pornography, but the very fact that it contains something that might eventually be considered pornography, you have to alert the recipient to the fact that this mail will contain sexually explicit material. This is all part of your obligation if you're going to engage in this kind of marketing. Finally, employment. As I said before, employment in the United States does not have a federal law. However, federal government agencies are required to adhere to, obviously, the American Constitution, where the Fourth Amendment prevents against search and seizure. So that is the amendment, or that's the piece of legislation that's most frequently used to say, okay, well, look, I can't go and search or video survey my employees. It has been extended in California to all employees, but it just outside of California, it only extends to federal government employees. I've also listed, just for information purposes, laws that do contain certain pieces of information concerning employment and also record keeping. So all of these laws deal with record keeping. And I'm racing because I really want to get to the California Consumer Privacy Act. The California Consumer Privacy Act is a really interesting piece of legislation, and I'm sure everybody's heard a lot about it because it's very equivalent to the GDPR. And when you consider that California is a larger economy than Canada, it's pretty impressive that the state has put together this law. However, it is not as it's, I wouldn't say lenient, but it's a little more forgiving, I would say, than the GDPR. And you see that in its scope. So it only applies if you have in excess of $25 million of revenue. So this is great because it allows small and medium businesses to be exempted from the burden of compliance, at least until they get up and running. This has been one of the biggest comments that has been made against the GDPR, is that it's just really onerous for small and medium businesses. It also applies if alone or in combination you buy, receive for the business's commercial purpose, sell or share for commercial purposes, alone or in combination, the personal information of 50,000 or more consumers, households or devices. Interesting, it applies to households, which is not something the GDPR does. Or if a company derives 50% or more of its annual revenue from selling consumers' personal information. So what's really interesting about the California Consumer Privacy Act is that it basically says, okay, you know what, we're not going to put this burden on small and medium businesses, but if these small and medium businesses derive their revenue from data processing or engage in this activity as sort of their main activity, then okay, they are going to have to comply. So it's sort of a nice compromise that it reaches. A consumer is a natural person who is a Californian resident. And personal information is any information that identifies, relates to, describes, or is reasonably capable of being associated with or could reasonably be linked directly and indirectly with a particular consumer or household. Not clear what household means at this stage, but I think it's probably to cover the kinds of information that these Alexas or these, whatever they are, these robots in your house collect. So I think it's there to cover that eventuality. The consumer has the right to know what personal information is being collected about them, how it's sold and disclosed and to whom, the right to say no to the sale of personal information, the right to access their personal information, and the right to get equal services and price even if they decide that they don't want you to use their personal information. It's interesting because it comes back to what Europe is doing with its cookie blocking or its cookie walls, its legislation against cookie walls, and also the fact that you're not allowed to sell somebody's information. California, long before the California Consumer Privacy Act, was quite strict on forcing people, their California Online Protection Act, Privacy Protection Act, required organizations to tell people if their information was being used by a third-party processor, how that third-party processor was using the information, and what you could do in order to stop that. So California's been on this for a while. The penalties are quite steep, so it's 100 or to 750 per consumer per breach. 2,500 for an organization that has not remedied its breach within 30 days, and 7,500 for an organization that deliberately breaches the act. Now, this isn't sort of GDPR standards right away, but one thing that people are worried about is an industry growing out of these kinds of penalties where, you know, an organization does not remedy its breach within 30 days. That breach could just simply be, I failed to respond to your access request. So people are worried that there's going to be an industry of crazy access requests left and right, and then, oh, you didn't respond to me within 30 days, you owe me such and such. So we're not sure where this is going to go, but that's one of the questions that's out there. Now, just to conclude, some of the other states, and these are recent, that have passed laws. Well, obviously, California has its data broker law and its data breach law amendment. New York has the New York Shield Act. Illinois has the Biometric Information Privacy Act. That's a very interesting piece of legislation. I think it's only 2 years old. It may be older, but we're starting to see several cases under this particular legislation. And then Nevada recently also, interestingly enough, passed a Nevada Internet Privacy Law. So the United States is moving in the direction of more comprehensive privacy coverage, but still, right now, it still has a sectoral approach that is almost the absolute diametric opposite to what we're used to in Europe. Are there any questions? I'm sorry I was galloping through this last bit. Okay, Lucy, no questions?
No, I don't see any questions right now, so I'll just invite people. Oh, we have one. In the case where a Canadian bank is subcontracting its identity theft protection offering to a third party located in the USA, and that third party stores the personal information of the bank's customers in the USA, would that third party's responsibility fall under the financial sector data protection rules?
That's a really good question. Yeah, well, just a second. No, it probably wouldn't because it's not a banking institution. So that the federal banking protection, or yeah, federal banking privacy protection laws apply to a very limited category of institutions. So what the, I guess, would be a cloud provider or with some form of security or some form of server, that server isn't acting as a financial institution, so it wouldn't technically be caught by the financial sector regulations. Now, if it were held out to be one of the entities covered by these acts, it would be. And these acts are quite clear as to what they apply to. But it's a tricky question and a good one.
We have another question here. So
oh, yeah.
Many companies, especially in the financial sector, have started using behavioral analytic tools to study the behavior of their employees with the main purpose of detecting any potential fraudulent behavior of their employees. Are these legal? It may be harder to use such SW in California, for example.
This is a really interesting question because there is not a lot of legislation surrounding employee monitoring in the United States. There is some, but not a lot. And the first place that we're told to go in order to have an answer to this is either the employment contract, which should specify whether the individual has the right to be monitored, or a collective bargaining agreement. There are, however, there is the, what is it called, the Employee Polygraph Privacy Act, which protects employees from being subject to polygraph, and lie detector tests federally, unless you belong to a certain sector. But the sectors are pretty restricted to be like defense or security or things like that. So there are certain laws in the United States that don't allow for this kind of out-and-out monitoring. So are they legal? Yeah, it would depend on the state you're in, but I would be very careful before I started using them, and very cautious on how I use them. And the employees regardless will have to be informed that they're being used. You can't just do it behind their backs. Are there other questions?
No, if anyone has
Okay.
questions, they can feel free to put in the Q&A, but I don't see anything right now.
Okay. Well, I guess this concludes the series. Thank you so much for putting up with us and listening and asking really excellent questions. I really enjoyed this, and thank you very much, Lucy. Thank you to Miguel.
Oh, no, thank you, Danielle, and we look forward to seeing you again.
Thanks. Bye.
Bye.
Penny.